Let's talk about the importance of inserting exemption or limiting terms in your contractual documents. These are terms that people, in addition to the original terms and conditions of a contract, people make additional terms to be able to define their level of liability in a business. But you must look at the peculiarity of your business and choose what works for you. Or the lawyer who is drawing up that document for you must also be knowledgeable in that field of business to know what terms to insert. But one thing is that you must also bear it in mind that there must be an intention to be bound by such exemption or limiting terms. For instance, I had this cleaning agent who I contacted to do a cleaning job for me. In her invoice, she stated that if a party cancels 2 days before the agreed date, that the person will pay a certain percentage of the total agreed sum. And I called her to confirm if that was a part of the agreement that she was willing to keep, and she said yes. So I made about 70, she requested for 70% of payment, which I did to commit her. 2 days after receiving that money from me, she called in to say that it was not going to be possible to commence on the agreed date. So I asked her, how do you want us to enforce the exemption clause that you included in your invoice? At that point, she started begging me and all that. So this brings me to the point that most people who insert these things just copy conditions, copy terms from other people's document without knowing the legal implication of such terms. Exemption clauses or limiting terms in a contractual document is there for one purpose only: to limit liability. An example I will give to you is a situation where a civil engineer has been contracted by a house owner to come and develop a project, a property for him. They have agreed on the terms, they have agreed on the consideration to be furnished, and then, in addition to that, the civil engineer now draws the attention of the house owner to tell him that, look, when we go to the market to purchase the building materials and we bring them to the site, you will be solely responsible for the safety and the keeping of these items. I will not be held liable if there is a theft. I will not be held liable if any of these items are destroyed. That is what we call an exemption clause. So, should it happen that after they returned from the market and dropped those items there on site and everybody goes home, only to come back to site the next day and discover that those things were missing or destroyed, the civil engineer has succeeded in reducing his what? Liability. Nobody will question him. He will not take responsibility for the replacement of those missing items. That is the work of a limiting clause or an exemption clause in a contractual document. I hope you have learned something today. Bye bye.